During war, the President of the United States and Congress are, of necessity, bestowed with certain wartime powers that affect constitutionally guaranteed rights and civil liberties of citizens. President Lincoln, in his dual role of President and Commander-in-Chief, made a controversial, unprecedented, but necessary move early in the war when he decided to suspend the privilege of the writ of habeas corpus. Article 1, Section 9 of the United States Constitution states, "The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it." The term habeas corpus is Latin for "may you have the body." A writ of habeas corpus is a judicial order that requires a person who is detaining another to bring the detained person, the body, to a judge who will determine then if the person is properly detained under the law. Its purpose is to provide redress to a person who has been illegally arrested or unlawfully detained or imprisoned. The Constitution does not say who may suspend the privilege of issuance of a judicial writ of habeas corpus. However, because the clause relating to suspension of the writ, also known as the suspension clause, is found in Article 1 of the Constitution, which deals primarily with the powers and duties of the legislative branch, the argument was made at the time by some that only Congress can suspend the writ. After Virginia seceded from the Union on April 17, 1861, the Union Army needed access across Maryland to transport troops and supplies to Washington, D.C. While Maryland was still a part of the Union, there were many Confederate sympathizers in Maryland who were vocal supporters of the Confederacy. On April 19, 1861, as Union troops attempted to cross through the city of Baltimore, the troops were attacked by a mob. Fighting between the soldiers and the mob ensued, and the violent confrontation resulted in the deaths and casualties of both Union soldiers and civilians. After the incident, Lincoln was informed that the Maryland legislature planned to assemble and vote to sanction resistance against the Union troops. On April 25, 1861, Lincoln wrote to General Winfield Scott a letter in which he gave Scott the authority to suspend the privilege of the writ, quote, "in the extremest necessity." On May 25, 1861, a Marylander named John Merryman was arrested for acts of treason by preparing men to serve in the Confederate Army. He was then detained at Fort McHenry. His lawyer quickly requested a writ of habeas corpus, and Chief Justice Roger B. Taney issued a writ that ordered the Union Army to bring Merryman to court. Union Major General Cadwalader refused to release or produce Merryman on the grounds that the privilege of the writ had been suspended. Now, it is important to stop here and note that Lincoln suspended the privilege of the writ without an act of Congress, which was not in session in April of 1861. However, over 2 months later, on July 4, 1861, he delivered a message to Congress at a special session in which he explained his power as president to suspend the writ. Lincoln opens his message by pointing out that extraordinary circumstances necessitated that Congress meet in special session, and making it clear that the topic to be discussed was far from usual lawmaking. He states, "Having been convened on an extraordinary occasion, as authorized by the Constitution, your attention is not called to any ordinary subject of legislation." Lincoln next sets the stage for describing the state of war that existed since the beginning of his presidential term. He points out the illegal seizure of federal property, as well as the avowed hostile purpose of the Confederate States. He says, "At the beginning of the present presidential term, 4 months ago, the functions of the federal government were found to be generally suspended within the several states of South Carolina, Georgia, Alabama, Mississippi, Louisiana, and Florida, excepting only those of the Post Office Department." And then he goes on to name the federal properties that were seized by the Confederates. He ends his paragraph by reminding Congress that the Confederates had aggressively attacked United States forts, such as Fort Sumter. The forts remaining in the possession of the federal government in or near these states were either besieged or menaced by warlike preparations, and especially Fort Sumter was nearly surrounded by well-protected hostile batteries with guns equal in quality to the best of its own, and outnumbering the latter as perhaps 10 to 1. In this part of the message, Lincoln is laying the foundation for justification for taking extraordinary measures at a time of hostilities against the Union. He sets up the case for arguing that the United States did not start this fight and is not the aggressor. Lincoln describes the acts of former United States soldiers taking up arms against the Union and concludes this portion of the address by pointing out the well-planned, premeditated strategy of the seceding states to establish a separate government and, indeed, a separate country. He says, a formula for instituting combined government of these states has been promulgated, and this illegal organization, in the character of Confederate States, was already invoking recognition, aid, and intervention from foreign powers against the Union. In the next part of the message, Lincoln discussed what he pledged to do in the first inaugural speech with respect to maintaining the peace and keeping the federal government operating. He makes it clear that the federal government did not plan to engage in unnecessary force, but that it was committed to keep the functions of government operating if peaceful measures did not succeed. He says, finding this condition of things and believing it to be an imperative duty upon the incoming executive to prevent, if possible, the consummation of such attempt to destroy the federal union, a choice of means to that end became indispensable. This choice was made and was declared in the inaugural address. The policy chosen looked to the exhaustion of all peaceful measures before a resort to any stronger ones. Lincoln moves on in the message to the necessity and propriety of suspending the privilege of the writ under the current situation. He first gives an assurance that the authority to suspend the writ has been exercised very sparingly. Then Lincoln addresses the argument that he has violated his oath of office by suspending the writ, and he turns the argument around to support his action. He says, the attention of the country has been called to the proposition that one, meaning Lincoln, who has sworn to take care that the laws be faithfully executed, should not himself violate them. Of course, some consideration was given to the questions of power and propriety before this matter was acted upon. The whole of the laws which were required to be faithfully executed were being resisted, and failing of execution in nearly 1/3 of the states. Must they be allowed to finally fail of execution, even if it had been perfectly clear that by the use of the means necessary to their execution, some single law made in such extreme tenderness of the citizen's liberty that practically it relieves more of the guilty than of the innocent, should to a very limited extent be violated? To state the question more directly, are all the laws but one to go unexecuted and the government itself to go to pieces, lest that one be violated? The single law that Lincoln refers to, which is highlighted in the above passage, is the constitutional provision that guarantees the right to obtain a writ. His eloquent question asks whether it makes sense for the guarantees against suspension of the writ to be observed while all other laws were being violated by acts of rebellion. At this point, Lincoln seems to be arguing that violating the law against suspending the writ was justified due to the circumstances. However, as Professor Pinsker points out, this statement was one that Lincoln considered to be hypothetical because, as the next passage shows, in Lincoln's view, his act of suspension of the writ was completely lawful. First, Lincoln notes the state of rebellion that existed. He says, the provision of the Constitution that the, quote, privilege of the writ of habeas corpus shall not be suspended unless when, in cases of rebellion or invasion, the public safety may require it, unquote, is equivalent to a provision that such privilege may be suspended when, in cases of rebellion or invasion, the public safety does require it. It was decided that we have a case of rebellion, and that the public safety does require the qualified suspension of the privilege of the writ, which was authorized to be made. Lincoln then takes the argument that Congress exclusively has the power to suspend the writ head on. He says, now it is insisted that Congress, and not the executive, is vested with this power. But the Constitution itself is silent as to which or who is to exercise the power. And as the provision was plainly made for a dangerous emergency, it cannot be believed the framers of the instrument intended that in every case the danger should run its course until Congress could be called together, the very assembling of which might be prevented, such as was intended in this case by the rebellion. Here, Lincoln is making a practical argument to determine the intent of the founding fathers when they drafted the suspension clause. At the time the Constitution was drafted, travel was difficult. The same was true in 1861. Lincoln is pointing out the difficulty of calling together the members of Congress to take a vote to suspend the writ in a time of rebellion. He makes a valid point here because when the Baltimore Rebellion occurred in April of 1861, Congress was in recess. Getting members back to Congress for quick action would have been difficult, if not impossible. Now remember that in May of 1861, Chief Justice Taney had held that the President did not have the power to issue the writ of habeas corpus in the Merryman matter. His reasoning was based upon the fact that the President's powers were listed in Article 2 of the Constitution, whereas the suspension clause was found in Article 1, which is devoted to the legislative branch. Although Lincoln does not directly challenge Taney's decision in his message, or expressly refer to the Merryman opinion, he refused Taney's reasoning in the opinion in a shrewdly subtle way in his message. He states, "Now it is insisted that Congress, and not the executive, is vested with this power, but the Constitution itself is silent as to which or who is to exercise the power." There should not be any doubt that while he did not directly mention Justice Taney's decision in his message, Lincoln was turning to Congress for support for his action. Lincoln then brings in the backup by advising Congress that he has asked Attorney General Edward Bates to render an opinion on the legality of his actions. Bates did issue an opinion the next day in which he concluded that the President had ample constitutional power to suspend the privilege of the writ of habeas corpus. Now, I'd like to digress for just a moment to point out that noted scholar Mark Neely argues quite persuasively that Justice Taney was the one who was actually exceeding his authority in the Merryman case by directly violating provisions that had been established since Marbury versus Madison regarding judicial authority in issuing select writs. The next part of Lincoln's message addresses the nature of the acts of the Confederate States and reinforces that these acts are nothing less than rebellion and lawless. He says he will not allow what he refers to as the movement of the rebel states to be sugar-coated by using the term secession. To the contrary, he calls the movement treason and accuses the leaders of the movement of trying to persuade the public that what they were doing was legal. Lincoln states the following: "It might seem at first thought to be of little difference whether the present movement at the South be called secession or rebellion. The movers, however, well understood the difference. At the beginning, they knew they could never raise their treason to any respectable magnitude by any name which implies violation of law. They knew their people possessed as much of moral sense, as much of devotion to law and order, and as much pride in and reverence for the history and government of their common country as any other civilized and patriotic people." He continues, "They, meaning the Confederates, knew they could make no advancement directly in the teeth of these strong and noble sentiments. Accordingly, they commenced by an insidious debauching of the public mind. They invented an ingenious sophism, which, if conceded, was followed by perfectly logical steps, through all the incidents, to the complete destruction of the Union. The sophism itself is that any state of the Union may, consistently with the national Constitution, and therefore lawfully and peacefully, withdraw from the Union, without the consent of the Union or of any other state. The little disguise that the supposed right is to be exercised only for that cause, themselves to be sole judge of its justice, is too thin to merit any notice." In refusing to agree that the Constitution allows one state or more to decide to leave the Union without the consent of the Union, Lincoln is hearkening back to his first inaugural address when he said, "If the United States be not a government proper, but an association of states in the nature of a contract merely, can it, as a contract, be peacefully unmade by less than all the parties who made it?" In addition to using the terms rebellion and treason to describe the acts of the Confederacy and its leaders, Lincoln proceeds in his message to accuse those who have been part of the movement to secede to be traitors who have committed acts of treachery against the Union. In contrast to these traitors, Lincoln praises those officers and soldiers who remained loyal to the Union. He states that great honor is due to those officers who remain true despite the example of their treacherous associates, and he commends those loyal soldiers who have successfully resisted the traitorous efforts of those whose commands but an hour before they obeyed as absolute law. Lincoln goes on to explain that plain people instinctively know that destroying the government which was made by Washington means no good to them. Lincoln then returns to the necessity for his exercise of his war power to suspend the writ. His argument in the next passage is that he was elected by the people to be president and that he could not ignore the obligation to save the Union from destruction, even if it meant taking extreme steps to avoid demise. Lincoln says, "It was with the deepest regret that the executive found the duty of employing the war power in defense of the government forced upon him. He could but perform this duty, or surrender the existence of the government. No compromise by public servants could, in this case, be a cure. Not that compromises are not often proper, but that no popular government can long survive a marked precedent, that those who carry an election can only save the government from immediate destruction by giving up the main point upon which the people gave the election." Lincoln continues, "The people themselves, and not their servants, can safely reverse their own deliberate decisions. As a private citizen, the executive could not have consented that these institutions shall perish. Much less could he, in betrayal of so vast and so sacred a trust as these free people have confided in him. He felt that he had no moral right to shrink, nor even to count the chances of his own life in what might follow. In full view of his great responsibility, he has, so far, done what he has deemed his duty." In this passage, Lincoln is referring to his own responsibility as an elected official, elected by the people. If they don't like his decisions, they can elect someone else. But right now, he has to follow what he thinks is right. Lincoln ends the message by stating, "The citizens will do their duty," and apologizing for disturbing their rights, which is a reference to his order suspending the writ. He assures all faithful citizens who have been disturbed in their rights of certain and speedy restoration to them under the Constitution and the laws. In the North, the public reaction to Lincoln's address and the suspension of the privilege of the writ of habeas corpus was generally favorable. Even before he delivered his message, the New York Times took a broad view of Lincoln's military powers, including the right to suspend the writ. After first acknowledging the vast deal of patriotic indignation among the Southern sympathizers just now over what they are pleased to term the unconstitutional suspension of habeas corpus, the editorial stated the following: "It is a great fallacy to suppose that the civil authority is at all times and under all circumstances superior to that of the military. In the presence of an enemy, when there is actual danger of collision, when the strong arm of physical force is necessary to save the country from imminent peril, the civil power must give way, for the time, to the military. It needs no constitutional provision, no legislative enactment to legalize its authority. It is inherent in the nature of things, existing from necessity, growing out of, and is a part of the great law of instinct and self-preservation, which is higher than constitutions, older and stronger than the statute book." Lincoln never went that far to justify suspension of the writ during the Civil War. However, he continued to maintain that he did not need the authority of Congress to suspend the writ. Congress did enact a law in March of 1863, authorizing the president to suspend the writ in times of rebellion. However, notwithstanding enactment of the new law, Lincoln stood firm throughout the war as to his own authority as president and as commander-in-chief to suspend the privilege of the writ under his wartime powers, with or without the blessing of Congress.